Hi guys, so today we are going to discuss regarding the new Model Tenancy Act, which has got approval from the Union Cabinet, and I mean the reason why this act has come into force is because the existing rent control laws and the tenancy laws which are there have discouraged the owners from renting out these their houses because of fear of repossession, and primarily because a lot of litigation is pending in courts, and it takes the owner years and years to get a tenant vacated. Nearly 1 crore houses were lying vacant in 2011 primarily because of this. So this is a new act which has been piloted by the Ministry of Housing and Urban Affairs, and Harika is going to take us through the salient features of this act. So Harika, over to you.
Owners are generally getting discouraged from renting their vacant houses, keeping in post consequences in the mind, like what happens if at the end of the tenancy period, what happens if the tenant is not willing to vacate the premises, or what happens if any rent issue arises. So this Model Tenancy Act is covering all these issues by bringing transparent and accountability into the existing system of renting of premises. So this act also balances both the interest, like both the landlord and tenant interest, and made provisions accordingly.
Yeah, just to
So
add on, Harika.
yes,
Okay,
yes,
so the current format in which if a owner wants a tenant to vacate his house, first and foremost he has to do it in accordance with law,
it's an agreement.
and
Yes,
he needs to issue a notice under 106 TP Act, Transfer of Property Act, and after that particular notice, if 30 days notice is given and the tenant doesn't vacate, or in accordance with the contract, if 2-3 months notice has to be given, and even in spite of the notice the tenant does not vacate, the only recourse for an owner is that he has to file a suit, eviction suit, before the civil court or the district
yes,
court or small causes court, wherever the need be, and
yes,
he has to provide sufficient reasons for that particular vacating that particular premises. It could be commercial or residential, and after that a notice has been issued to the tenant, who comes forward, engages a lawyer, files his defense, and then there is evidence which begins, and then arguments, and finally the judgment. Now, even after the judgment, let's say he does not vacate, then he again has to file an execution of that particular judgment and decree. And because of this, the entire process, okay, considering, like, let's say somebody goes on an appeal, and after appeal, it just can drag on to like 5 years, 10 years. There are several such suits which have been pending in the system, and to be disposed. And I think this should be a welcoming step. So I'm keen to know more about this act. So go ahead.
okay. So I'll be talking about its future. So this act will have a prospective effect. So whatever agreements have been entered into prior to the commencement of this act will not go govern such type of agreements. So those prior agreements will have no effect when it comes to this Model Tenancy Act 2020.
Okay.
So so once after the commencement of this act, once the states adopted this act, there is this obligation on both the parties, landlord and tenant, to inform to the rent authority within 2 months of their agreement. Once they have entered into the agreement, within 2 months they have to inform it to the rent authority. So in case they fail to inform, they can individually inform to the rent authority within 1 month from the expiry of those 2 months, as I mentioned before. So this is one
Mm-hmm.
of the obligation on both the parties.
Okay.
So there is this authority will be established under this act called rent authority, which will so once this authority is established, so it should establish a digital platform in the local language, like respective to the state's local language, within 3 months of its establishment. Okay, and then once it is established, it will so this the main objective of this digital platform is to upload all the agreements documents related to both the landlord and tenants.
Okay.
So
Interesting.
once
So I just think that here they are just going to make one platform where both the landlord and tenant can see the lease agreement as well, and maybe renew the lease agreement, and the agreement will be in place. So I guess that is a very good welcoming step there.
yes sir. So adding to this point, once both the landlord and tenants will uh, inform to the rent authority within the respective specified time period, the rent authority will look into the application, and within 7 working days it will provide one ID, specific ID, so that they can have access to that digital platform to the parties. And also within that 7 working days, the rent authority will be uploading the all the required documents with respect to that agreement.
Mm-hmm. Okay.
So another provision of this act is talking about subletting the premises. So in case when the tenant wants to sublet its premises to another person, so it should be done only with the consent of the landlord. And once the landlord has consented to it, it should be done on supplementary agreement, and another agreement with respect to that subletting should be done. And all this information should be informed to the rent authority as well within 2 months period.
Okay, fine. All right, that is good. And one of the important things, I guess, is this is a central law, and the tenancy as such is a state subject. So I guess all the states have to adopt this particular law, right?
It's like up to them, sir. It's like there is no obligation, but obligation from the union government on the states. But the government clearly mentioned that the states has to adopt or amend it as per their previous rent control acts.
Absolutely. So I can just imagine that, because this should be a welcoming step, and I think no state should think twice before doing that, because there was no such intimation. And I mean, most of the agreements, what used to happen used to be 11-month agreement, which are neither notarized, and just between both the parties which have been signed. And there is also an evasion of stamp duty at a lot of ends. And because of this, now what is going to happen is all the rent agreements are going to be available with the rent authority, and even online and a digital platform to view it for everybody. Great,
Yes.
great, great. Proceed, Harika.
So I would like to mention a point when it comes to subletting the premises. So when this act is silent about at what rate that does a tenant can sublet its premises, like I have seen when it comes to our state Andhra Pradesh Tenancy Act. So it clearly mentioned that a subtenant tenant cannot sublet its premises for more than 50% of rent which he is paying. So this act is not talking about such provisions or not giving any specific amount of.
Okay, that's interesting take out there, because I think they are going to, if it comes into picture, they're going to make special rules as well, and maybe these sort of things might be addressed over there.
Also, if the states which is not having such provision, like for example, take instance of Andhra Pradesh Act only, it has specific provision like not more than 50% of rent.
Hmm.
So it won't repeal. It won't It won't repeal that provision. That provision will be in practice. So the state people can have such kind of limitation on their rent when it comes to a subletting their premises.
Okay, okay.
So when it comes to inheritability, this act clearly mentions that in case of death of any landlord or any tenant, in the event of such death, their respective rights and obligations with respect to that tenancy agreement will be passed on to their heirs as well, and they will have same they will be have same rights
Same
as of the
rights.
yes, as
Okay,
like tenant and landlord.
okay, all right.
So when it comes to the period of tenancy under this act, it has a clear provision that it will be governed. The period of tenancy will be as per the provisions of the, I mean, as per the terms of the agreement itself. So, apart from this, when a tenancy period, when it comes to an end, that agreement can be renewed or extended by the parties. And if such renewal or extension cases of the agreement, that also should be informed to the rent authority as well. So in case the tenant fails to vacate the premises, maybe on the period of tenant when the period of tenancy comes to an end, or when an eviction order has been passed under section 21 of this act, so there is a penalty will be imposed on such tenant to pay 2 months of rent excuse me, 2 months of rent when it comes to cases where he's not vacating in the first 2 months, and and if he's continuing for the remaining months, he has to pay 4 months of rent.
Oh, so he has to spend 4x of the monthly rent if he does
Yes, in
not
case,
vacate after.
yes,
So just a step back, Harika.
yes,
So basically, if a tenant fails to vacate, I guess we have to file a complaint before the rent authority,
yes, sir.
right?
Because it is one of the ground which is provided under section 21, which we'll be discussing further.
Further, is it? Okay, okay. All right.
So also there's an another clause mentioned in this act, force majeure event. So when the period of tenancy is coming to an end, and at that point of time where there is any force majeure event happening, like floods, earthquakes, tsunamis, cyclones, whatever. So in such instances, on request of the tenant, the landlord can extend their period of agreement to another 1 month on the same terms which as they entered before.
Okay, okay. So I think, one of the major eye opener during this pandemic was this force majeure clause, which is there, which is missing from most of the rental agreements. And I guess they have tried to address that as well over here. And even this particular point where it says that twice the monthly rent or 4 times the monthly rent will have to be paid is something which would actually deter any tenant from overstaying in a particular premises illegally after a certain point.
Yes, sir.
Yes.
So this act, chapter 3, is talking about these rent provisions. At what will be the rent, and regarding the revision of rent and all. So also, as we discussed earlier, period of tenancy, its rent and everything will be as per the terms of the tenancy agreement, as per the agreed. So in case there's any revision of rent, which is mutually agreed, it has to be revised by on mutually agreed terms, and it will become effective within 1 month of such uh, revision. So there is this provision for both the parties to file an application before rent authority in case if any type of disputes arises. So there are few instances where we can approach rent authority in case of a dispute. Like, okay, I'll discuss all the provisions and we'll come to that. So this act also mentions about the security deposit. What amount has to be deposited when it comes to security deposit priorly, like generally it is also as per the agreed, but this act gave the ceiling thing, like not more than 2 months of rent should be taken as a security deposit when it comes to a residential premises, and not more than 6 months when it comes to non-residential premises. And when at the vacation when the period of tenancy come to an end, or any eviction order passed, such security deposit will be refunded back on the day when the landlord will have the possession of the property itself, premises itself.
Okay, that is interesting because just take that back. Yeah, so because generally the format what has been followed all throughout all the metros is that there is a minimum of 10 months of like rent which is charged as security deposit. I guess the entire idea is because these litigations take such a long time that they know that 10 months is like very ideal to keep the security deposit. But now if this law is adopted by all the states, it is going to reduce the security deposit to merely 2 months. So I guess there should be a faster way of dispute resolution system also with the rent authority, as you have told that in case of any dispute, we can file
There,
before the rent authority. So I guess there should be a timeline as well regarding
there
that.
is,
Yes, yes.
there is,
Okay,
there is.
go ahead. Is there a timeline prescribed for the rent authority to dispose of any of these applications?
No, in the act, not specially. It was mentioned, but in general, it mentioned that within 60 days, uh, an application should get disposed.
So that's what exactly. So that is the reason why they have only limited the security deposit to 2 months, because I guess within 60 days the application of any dispute has to be settled by the rent authority. So which is a very good thing.
Yes,
Yes, proceed, Harika.
yes, sure. So I have tried to cover all the duties of tenant and landlord, whichever is mentioned in the act in this slide. So let's look into the first point. So generally, in general, we all know this, like a tenant has a duty to pay rent and charges as per the agreed terms of the agreement. And on such payment, the landlord has to provide a duly signed receipt to the tenant as an acknowledgement of receiving that payment. So this is a general point. So also, the tenant has a duty to not intentionally or negligently make damages to the premises which is living in. So also, if in case any damage occurred which is not which is not occurred due to his actions, he has to inform to the landlord with respect to such damages, and he has a duty also has a duty to take reasonable care of the premises as if has to maintain the premises as if it was in the initial stages, like how he got the premises during the starting of the tenancy agreement. He should make sure that he should take reasonable care of the premises in such way. Also, the schedule 2 of this act mentions what what repairs and all should be taken by the tenant. So apart from the agreement which they have agreed into with respect to the repairs and maintenance, this act mentioned that the tenant has to make periodic repairs like changing taps, drain cleaning, um, um, geyser repairing, or in any with respect to switches, sockets, or any circuit breaking, and anything like that. Like schedule to mention these acts, like tenant is bound to make these repairs and maintain accordingly. So I've already discussed about this enhancement provision where in case he fails to vacate 2x of the 2x, 2 times the monthly rent in the first 2 months and all. I've already discussed this before. So there's also this provision availability given to the tenant under this act that in case um, the landlord fails to make his repairs as per this act, the tenant has a um, option to vacate the premises by giving a written notice. So such notice also, like within what time period with respect to giving such notice will be according to the provision of this act. In case the provisions of the agreement, and in case the agreement fails to mention such clauses, the act provides that it should be a prior 1 month. The notice has to be given prior to 1 month. So when it comes to the landlord, Schedule 2 of the Act also mentions what kind of repairs and maintenance has to be done by the landlord, like painting walls and whitewashings, wash and internal or external electrical wiring, or any roof changes, or these kind of things, these kind of repairs, landlord has a duty to do. So also, when it comes to property manager, landlord has a duty to inform tenant if he's appointing any property manager, he has to inform tenant with respect to the details of the property manager, the reason why he's appointed, and all. Also, there is a duty on this landlord and property manager to enter into the premises which was given to tenant. So such enter has to be done by giving a notice to them in any electronic mode, and such notice should be given prior to 24 hours. So also such notice has to mention the date, reason, time, and all, uh, when they are entering upon to the premises. And also such entering should not be done after sunset and before sunrise. The act clearly mentioned this. So as I already discussed before that, no, liable to pay interest. Yes, this when the landlord fails to give back the security deposit or any advance advance he has taken from the tenant, he is liable to return on vacating the premises. So in case if he is failing to refund all that, he is liable to pay interest as prescribed. So the act didn't mention any rate of interest. So it is upon the government to pass provisions accordingly. Also, when it comes to this prior notice thing, there are exceptions provided to it, like in case of emergency situations like force majeure clauses, which there is a possibility that those events will destroy the premises. Then there is no need of this notice rule to be followed by the landlord or property manager.
Okay, nice, Harika, that you've taken us through the duties of both tenants and landlord. One of the question what I had out here is like they have prescribed these repairs which are to be made by the tenant and the responsibilities of the landlord. Now, are these like compulsory, or is it all going to be as per the agreement? And these are just like certain guidelines which have been prescribed in the act.
So thing is, if they have agreed on certain terms, so the agreement can be go accordingly. So in case of absence of such mentioning the responsibilities, duties, or when it comes to repairs, then these guidelines will come into existence.
Okay, all right. Okay, Arika, proceed.
Also, excuse me. Okay. So
Yeah, Harika.
also talking about this act also provide provisions for the tenant to deposit of that rent or any charges to the rent authority. So there are three instances where a tenant can dispose the rent with the rent authority. So generally, when the landlord refuses to accept the rent or any charges for a period of 2 months, the tenant can pay through any postal or any other prescribed means. And then still he's refusing, then he can deposit the rent with the rent authority. So this is the first case. And the second case, when the tenant is unable to decide to whom the rent is payable, like the cases can arise where there is property manager and landlord are active when it comes to this agreement, and if the tenant is like a confusion is in a confusion state to whom it is payable, then also he can deposit it with the rent authority. Also, as I already discussed, landlord has or the property manager has a duty to give an acknowledgement receipt. So when he is refusing to give, then also he can deposit with the rent authority. And then on this application, looking into this application, the rent authority will decide to whom the rent has to be payable and will go accordingly. So when it comes to the repairs and maintenance of property, as I already told, Schedule 2 of this Act clearly mentions what kind of repairs and maintenance that a landlord has to take and what kind of repairs the tenant has to take. So there's a responsibility on the tenant to keep the premises in the good condition. And I've already discussed about the second schedule point. So when in cases where both the tenant and as well as the landlord will have common facilities. So in such cases, the responsibilities and maintenance with respect to those common facilities will be as per the agreement. They'll decide and maintain accordingly. So there are instances where the landlord can fail to repair as per the provisions of this act. So or when the tenant can refuse to make repairs as per the provisions of the act. So in such cases, there is a recourse provided under this act. So in case of tenant fails or refuses to carry out the repairs in the premises, then the landlord can carry and deduct from the security deposit. Also, in cases where such expenses is exceeding the security deposit, within 1 month, the tenant has to pay the security deposit along with the excess amount. So within 1 month, after repairing, the landlord will be issuing a notice to pay back the money, and within from that 1 month, the tenant is bound to pay back the money as per the provisions of this act. So when it's a case where landlord refuses to carry out the repairs, the tenant can carry out the repairs, and he can deduct the money from the rent he will be paying in the succeeding months. Also, this act clearly mentioned that such deduction from the rent should not be more than 50% of the agreed rent. So these are the cases like the recourses provided under this act. What happens in case of failure? So as already discussed before this point, so what happens when the premises becomes uninhabitable by the tenant? So the landlord, the instances where the landlord refuses to carry out the repairs, there are two options available to the tenant. So first thing, he can carry out the repairs. Tenant can carry out the repairs and he can deduct from the rent, which he'll be paying in the succeeding month. Or also, he can vacate the premises on 15 days prior notice. Also, on such vacation, he will receive the security deposit, and as well as any advance payment he made, he will be receiving all that back from the landlord. So, in cases where the premises has become uninhabitable to the any force majeure event, so until and unless till the landlord will make any repairs and maintenance with respect to that premises, there is no need for the landlord to charge rent until the premises is restored. So this act also mentions few provisions with respect to property manager, that the details of the property manager has to be conveyed to tenant, like proof and authorization, like he's legally authorized. Any proof with respect to that he's legally authorized to act as a property manager and reason for its appointment. And also, if such property manager is a legal entity, then the details with respect to person who is acting on behalf of the legal entity, and the details of the legal entity has to be conveyed to the tenant. So here are few duties of the property manager mentioned in the act, like they are very similar to the landlord duties. So like to collect, he is basically representing the landlord in the absence of landlord. So the duties like to collect rent, carry repairs, inspect premises, to give notices, or like notices with respect to maintain premises in a good condition, or to vacate, or to renewal extension, such kind of things property manager can give notices to the tenant. Also, the property manager can resolve the disputes if there are multiple number of tenants, or any disputes between landlord and tenant. Property manager can come into existence, and he can clear such disputes. So these are the duties, and in case of any contraventions of this, any contravention of the provisions by the property manager, an application can be made by the tenant or landlord to the rent authority, and the rent authority will look into the application and will either order to remove him from the property manager post, or either order to compensate for any loss caused due to such contraventions by the property manager. Also, this act clearly mentions that no property manager or landlord cannot withhold any essential supply or services. So, essential supply or services means like a supply of water, electricity, lifts, staircases, such kind of things will come under this category. So, in case the landlord or property manager is withholding such an essential supply or services, then an application can be made by the tenant to the rent authority, and the rent authority will look into the application and can pass an interim order, keeping its inquiry beside. So such inquiry can be completed within 1 month of such application, And in case the rent authority finds that such withholding of essential supply or services is done, then can order to compensate and such compensate the tenant, and such compensation should not exceed 2 months of the rent. And also when the rent authority finds that application is not made on a on like with a malified intention or is not made on proper grounds, and then also the rent authority can impose penalty on such applicant, like he should pay not, but that penalty should not be more than 2 months of the monthly rent. So I'll be talking. So now in this, I'll be saying like there are few instances where we can approach rent authority. There are instances where we can approach rent court. We have completed all the instances where when it comes to rent authority, like deposition of rent can we can go to the rent authority and deposit rent. When it comes to uploading documents, rent authority has a duty to upload documents and to provide an ID. And also, when it comes to any dispute with respect to revision of rent, rent authority has this duty to look into that application. And when it comes to any contravention provisions of property manager, also rent authority will be looking into that application. And when it comes to withholding supply or services or repairs, rent authority will be looking. So in these cases where an eviction order can be passed to the tenant, rent court has a duty to look into that kind of applications. And this act, under section 21, there are few grounds mentioned on what grounds a tenant can be evicted on an order. So as I mentioned here, a tenant does not agree to pay rent as per the agreed terms, or if tenant has not paid rent for a period of 2 months. So generally what happens in those cases, a notice will be sent to him, and if he's not responding to that notice within the 1 month period, within 1 month from such sending notice, an application can be filed to the rent authority. And such note, this act mentioned that such notice should be as per clause 4 of section 106 of TP Act, I mean Transfer of Property Act. Also, another case where the tenant, sublet the premises or parted premises that without obtaining the written consent, as we already discussed before, it should be subletting should be done on consent of the landlord. So, if the tenant misusing the premises even after notifying by or even after notification sent by the landlord, in such cases also application can be filed for eviction. Also, in case where landlord has to carry any repairs, construction, buildings, or any alterations, and such alterations, repairs has to be done on a if the tenant will vacate the premises only. In such cases, also the court may look into that application and provide a remedy accordingly. Also, in cases where a written notice has already been sent to the tenant to vacate, and on such giving notice, the tenant has subsequently contracted to sell the whole premises. So in such cases, like the interest of the landlord will definitely get affected. So in such cases, also an order can be given. Also, if the tenant carried any structural changes without the consent, generally such kind of permanent changes should not be done by the tenant unless there is a consent. So if the tenant without consent he has done any such act, then an eviction order can be passed on him. Also, if there is any bona fide requirement for the legal heirs upon a death of the landlord, so an application can be filed to rent authority, and then rent authority will be seeing if there is really a bona fide requirement for the legal heirs with respect to that premises. Then the rent authority will pass an order accordingly. Also, this act mentioned uh, see the general rule key within 60 days an application should get disposed. But when it comes to this eviction order applications, 10 when it comes to this C and D clauses, if you see, the application should be disposed within 30 days, like when it comes to parting premises or misusing premises. And in the remaining cases, the application can be disposed within 90 days. Also, this act clearly mentioned three authorities under this act. So when it comes to rent authority and rent court, we already discussed about them. So in case of a rent authority, uh, such person should be an officer not below the rank of deputy collector, and he should be appointed by district collector on consultation with the respective state government or union territory administration. He should be appointed. Also, when it comes to the rent court, an additional collector or additional district magistrate or any person who is equivalent to that post should be appointed, and he will also be appointed by the district collector only. And when it comes to the rent tribunal, the state government or the union territory administration will appoint an officer with consulting the respective jurisdiction of high court, whether it's states or anything. A district judge or additional district judge will be appointed as a rent tribunal. So this act has a three-tier dispute resolution mechanism. So generally, any person, as I already discussed, what kind of cases can a rent authority can be looked into. Rent authority will be looking and will pass an order accordingly, and within 30 days, an appeal from those instances or from those disputes, an appeal can be lied to rent court. So from rent court, within 30 days, an appeal can be lied to rent tribunal. Yeah, this is what Act has mentioned about these authorities and the appeal provisions. So this Act also mentioned what cases the premises in question, if it is owned by the central government or union territory administration or any authority, local or authority or statutory bodies, then in such cases, it will not this act will not be applicable. Also, when the premises is owned by the university or company or organization, and if it is led on if it is given on rent on a service contract base, then also this act will not be applicable. So also in cases where it is owned by these religious or charitable institutions, this act will not be applicable. And these religious and charitable institutions will be, as per the government will mention what kind of uh, institutions will be covered under this provision, and accordingly, this act will not be applicable. So these are the few provisions. Premises owned by the work or other premises exempted by respective government in public interest. If the government clearly mentioned that this in this kind of premises, this act will not applicable, or in such cases. So these are the few cases where the act will not applicable. Also in cases where hotels or dharmashalas, or in cases lodging houses. So this act is silent about paying guest things, like if what happens if paying guest is also paying rent and living in a house, but that is not covered under this act. So these
Great,
are the
great. That is a very interesting and elaborate presentation, Arika. Thank you so much for
thank you,
that.
sir.
I just had one question. So the actually under this act, eviction suit can be filed only before the rent court and not before
Yes,
the rent authority, right?
yes, sir.
Okay, so rent authority primarily deals with all the basic disputes, and
Yes,
rent control, I mean, the rent
and
code deals with the eviction related part. And there's
yes,
also an appeal procedure also which has been prescribed under that, which is very
tenancy.
interesting. So
Yes,
let us anticipate, and we hope that this law comes to all the states very soon, because it will definitely help in reduction of the number of cases, and it will dispose the disputes faster, and it will be a win-win situation for both the landlords and tenants, right?
yes, sir.
Absolutely. Thank you so much, Harika, for that very good presentation. Thank you.
Thank you, sir.